Please be seated. The sitting is open. The Court meets today pursuant to Article 58 of its statute and Article 94 of its rules to read out in open court its judgment on the preliminary objections raised by the Russian Federation in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russian Federation, 32 states intervening. For reasons made known to me, Judge Robinson, who duly participated in the deliberation and the final vote in this case, is unable to sit with us today. I recall that the proceedings in the present case were instituted on 26 February 2022 by Ukraine against the Russian Federation concerning, I quote, a dispute relating to the interpretation, application, and fulfillment of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, end of quote. I shall refer to that convention as the Genocide Convention or the Convention. I further recall that by an order dated 5 June 2023, the Court decided that the declarations of intervention under Article 63 of the statute submitted by 32 states were admissible at the preliminary objection stage of the proceedings, insofar as they concerned the construction of Article 9 and other provisions of the Genocide Convention relevant to the determination of a jurisdiction of the Court.
Disconnect this. No, it's Carol. It's Carol.
In accordance with the usual practice, I shall not read out the introductory paragraphs of the judgment, which set out the main elements in the procedural history of the case. I shall also omit some paragraphs and summarize others. I shall therefore begin reading the judgment at paragraph 29. The full text of the judgment will, of course, be available at the close of the sitting. The Court first recalls the general background of the case. In the spring of 2014, an armed conflict erupted in the Donbas region of eastern Ukraine between Ukrainian armed forces and forces linked to two entities that refer to themselves as the Donetsk People's Republic, or DPR, and the Luhansk People's Republic, or LPR. Despite attempts to achieve a peaceful resolution, the armed conflict continues between 2014 and 2022. On 21 February 2022, the Russian Federation, by decrees of its president, Mr. Vladimir Putin, formally recognized the DPR and the LPR as independent states. In an address delivered on the same day, President of the Russian Federation stated, inter alia, that this decision was taken in light of continuing attacks against the Donbas communities and, I quote, the killing of civilians, the blockade, the abuse of people, including children, women, and the elderly, while the so-called civilized world, which our Western colleagues proclaim themselves the only representatives of, prefers not to see this, as if this horror and genocide, which almost 4 million people are facing, do not exist. End of quote. On 22 February 2022, the Russian Federation concluded what it refers to as two treaties on friendship, cooperation, and mutual assistance, one with the DPR and the other with the LPR. On the same date, the DPR and LPR requested military assistance from the Russian Federation pursuant to these, quote, treaties, end of quote. At 6 a.m. Moscow time on 24 February 2022, the President of the Russian Federation declared that he had decided to conduct what he called a special military operation in Ukraine. In his speech, he stated, I quote, in accordance with Article 51, Chapter 7 of the Charter of the United Nations, I have decided to conduct a special military operation with the approval of the Federation Council of Russia and pursuant to the treaties on friendship and mutual assistance with the Donetsk People's Republic and the Lugansk People's Republic, as ratified by the Federal Assembly on 22 February this year. Its purpose is to protect people who have been subjected to abuse and genocide by the Kiev regime for 8 years. And to this end, we will seek the demilitarization and the denazification of Ukraine, as well as the prosecution of those who have committed numerous bloody crimes against civilians, including citizens of the Russian Federation." End of quote. This special military operation was launched early in the morning on the same day. By a letter dated 24 February 2022, the permanent representative of the Russian Federation to the United Nations forwarded to the Secretary General of the United Nations the text of the address of the President of the Russian Federation of the same date, explaining that this address informed the citizens of Russia of the measures taken in accordance with Article 51 of the Charter of the United Nations in exercise of its right to self-defense. On 26 February 2022, the Ministry of Foreign Affairs of Ukraine issued a statement denouncing, I quote, "Russia's false and offensive allegations of genocide as a pretext for its unlawful military aggression against Ukraine." End of quote. The ministry asserted in particular, I quote again, "Ukraine resolutely denies Russia's allegations of genocide and rejects any attempt to use such manipulative allegations as an excuse for its unlawful aggression. The crime of genocide is defined in the Genocide Convention, and under that convention, Russia's claims are baseless and absurd." End of quote. On the same day, a few hours after the issuance of this statement, Ukraine filed its application before the court, together with a request for the indication of provisional measures. On 16 March 2022, the court indicated provisional measures, ordering in particular that the Russian Federation immediately suspend the military operations that it had commenced on 24 February 2022 in the territory of Ukraine. The armed conflict between the Russian Federation and Ukraine continues to this day. The court notes that Ukraine invokes Article 9 of the Genocide Convention as the basis of its jurisdiction. This provision reads as follows, I quote, "Dispute of a state for genocide or any of the other acts enumerated in Article 3 shall be submitted to the International Court of Justice at the request of any of the parties to the dispute." End of quote. The Russian Federation has raised 6 preliminary objections, contending that, 1, the court lacks jurisdiction as there was no dispute between the parties under the Genocide Convention at the time of the filing of the application. 2, the court lacks jurisdiction ration materiae. 3, Ukraine made new claims in the memorial, and these should be found inadmissible. 4, Ukraine's claims are inadmissible as the court's potential judgment would lack practical effect. 5, Ukraine's request for a declaration that it did not breach its obligations under the convention is inadmissible. And 6, Ukraine's application is inadmissible as it constitutes an abusive process. The court starts by considering the first preliminary objection, which concerns the existence of a dispute. It must first determine whether, on the date of the filing of the application, a dispute existed between the parties relating to the subject matter of the application submitted to the court. As the court has stated, the existence of a dispute between the parties is a requirement for its jurisdiction under Article 9 of the Genocide Convention. According to the court's established jurisprudence, a dispute is a disagreement on a point of law or fact, a conflict of legal views or of interests between the parties. In order for a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. As regards disputes concerning the alleged violation of an obligation, the two sides must hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. It does not matter which one of the parties advances a claim and which one opposes it. The court's determination of the existence of a dispute is a matter of substance, not of form or procedure. The date on which the existence of a dispute must be determined is, in principle, the date on which the application is filed. It must be demonstrated that, on that date, the respondent was aware or could not have been unaware that its views were positively opposed by the applicant. However, it is not necessary that a state expressly refer to a specific treaty in its exchanges with the other state to enable it later to invoke that instrument before the court. Nor is it always necessary for the respondent to have expressly opposed the claims of the applicant, since the silence of the respondent may be sufficient in certain circumstances for the court to infer the existence of a dispute. The court observes that there was, on the date of the filing of the application, a disagreement on the question whether genocide attributable to Ukraine had been or was being committed in the eastern part of its territory. Several organs of the Russian Federation, having the authority to represent the Russian Federation in international relations, issued statements indicating that acts of Ukraine constituted genocide against the Russian-speaking inhabitants of the Donbas region. The President of the Russian Federation declared in his address of 21 February 2022, which coincided with that state's recognition of the DPR and LPR, that 4 million people living in the eastern region of Ukraine were victims of genocide. The permanent representative of the Russian Federation to the United Nations, defending the recognition of the DPR and LPR before the General Assembly on 23 February 2022, claimed that the inhabitants of the Donbas region were victims of a blatant genocide. In his address of 24 February 2022, the President of the Russian Federation claimed that the purpose of what he called the special military operation was, I quote, to protect people who have been subjected to abuse and genocide by the Kiev regime for 8 years. Ukraine has consistently rejected accusations that genocide was being committed in its territory. The Ukrainian authorities had already, in the years before the launch of the so-called special military operation, denounced the activities of the Investigative Committee of the Russian Federation, which was charged, inter alia, with investigating alleged acts of genocide committed in the Donbas region as having no serious basis. In this context, as early as 2014, the Prosecutor General's Office of Ukraine initiated criminal proceedings against certain Russian officials who were members of the committee. Following the launch of the so-called special military operation on 24 February 2022, the Ministry of Foreign Affairs of Ukraine issued a statement denouncing, I quote, Russia's false and offensive allegations of genocide, end of quote. The Russian Federation could therefore not have been unaware that the applicant categorically rejected the allegations that it had committed genocide. Furthermore, Ukraine denounced the use of force by the Russian Federation denounced the use by the Russian Federation of allegations of genocide against it as a pretext for justifying what it called an unlawful aggression, stating that such baseless allegations were, I quote, an insult to the Genocide Convention itself and the international community's relentless efforts in preventing and punishing the world's most egregious crime, end of quote. Even though this statement was issued only shortly before the institution of proceedings, it is clear that the Russian Federation knew at that time that its views were positively opposed by Ukraine, which was accusing it of acting unlawfully by using the convention as a pretext to justify its actions against Ukraine. In the specific circumstances of the case, the court considers that Ukraine could seize it without further delay. The court concludes that on the date of the application, a dispute existed between the parties on the question whether the acts of genocide attributable to Ukraine had been committed in the Donbas region and on the lawfulness of the Russian Federation's actions allegedly undertaken on the basis of such an accusation. The Russian Federation's first preliminary objection must therefore be rejected. The court observes that there are two aspects to the dispute submitted by Ukraine, the essential characteristics of which are distinct, and which the court therefore considers it necessary to examine separately and in turn. The first aspect of the dispute arises from Ukraine's request that the court declare that, contrary to the allegations of the respondent, the applicant has not committed genocide. By such a request, Ukraine does not seek to invoke the international responsibility of the Russian Federation for an internationally wrongful act attributable to that state, it seeks a judicial finding that it has itself not committed wrongful acts that the Russian Federation has, falsely in Ukraine's view, imputed to it in public statements. The second aspect of the dispute arises from Ukraine's requests that the court find that the Russian Federation has acted unlawfully with respect to the Genocide Convention. The court notes that this second aspect of the dispute is fundamentally different in nature from the first. Ukraine seeks to invoke the international responsibility of the Russian Federation by imputing internationally wrongful conduct to it. The claims for reparation submitted by Ukraine are part of that second aspect. In view of the foregoing, the court addresses in turn the two aspects of the dispute thus described and examines, in respect of each aspect as necessary, the questions of jurisdiction and admissibility raised by the preliminary objections of the Russian Federation. The court then considers the preliminary objections in relation to the first aspect of the dispute. It starts by noting that during the oral proceedings, the Russian Federation stated that its second preliminary objection, in which it contends that Ukraine's claims must be dismissed because the court lacks jurisdiction ration materia under Article 9 of the Genocide Convention, does not concern the first aspect of the dispute. The court sees no reason to call into question its jurisdiction to entertain the first aspect of the dispute. It thus examines this objection only in relation to the second aspect of the dispute in a later part of the judgment. The court next turns to the third preliminary objection, whereby the Russian Federation contends that Ukraine's claim in the memorial is manifestly different from the one advanced in the application, and that it is therefore inadmissible. The court recalls its well-settled jurisprudence on the subject of additional or amended claims formulated in the course of proceedings. The court has declared that additional or amended claims formulated in the course of proceedings are inadmissible if they would transform the subject matter of the dispute originally brought before the court under the terms of the application. In this respect, the memorial, although it may elucidate the terms of an application, must not go beyond the limits of the claim as set out therein. An additional or amended claim is not inadmissible ipso facto. The decisive consideration is the nature of the connection between the claim presented in the memorial and the one formulated in the application. The court has identified two criteria for assessing whether the required connection exists. Either the additional or amended claims must be implicit in the application, or they must directly arise out of the question which is the subject matter of the application. The purpose of these criteria is ultimately to determine whether the additional or amended claims would transform the subject of the dispute originally brought before the court under the terms of the application. The court has recognized that claims advanced subsequent to the application may clarify the scope of the dispute. In the present case, both submission A in Ukraine's application, requesting the court to, I quote, adjudge and declare that, contrary to what the Russian Federation claims, no acts of genocide have been committed in the Luhansk and Donetsk oblasts of Ukraine, end of quote, and its amended submission B in paragraph 128 of the memorial, which asks the court to, I quote, adjudge and declare that there is no credible evidence that Ukraine is responsible for committing genocide in the Donetsk and Luhansk oblasts of Ukraine. These concern the same allegations of genocide made by the respondent. The court is of the view that Ukraine's amended submission B merely clarifies the claim as presented in its application and therefore does not transform the subject of the dispute originally brought before the court under the terms of the application. Accordingly, in the remainder of the judgment, the court considers that the first aspect of the dispute to be defined in terms of Ukraine's submission B in its memorial, namely, whether there is credible evidence that Ukraine is responsible for committing genocide in violation of the Genocide Convention in the Donetsk and Luhansk oblasts of Ukraine. In light of the foregoing, the court finds that the Russian Federation's third preliminary objection to the admissibility of Ukraine's submission B in paragraph 178 of the memorial, based on the introduction of additional or amended claims, must be rejected. The Court turns next to the fourth preliminary objection, whereby the Russian Federation contends that a potential judgment of the Court on Ukraine's submissions would be devoid of any practical effect. The Court recalls that even if it finds that it has jurisdiction, it is not compelled in every case to exercise it, because there are inherent limitations on the exercise of the judicial function which the Court, as a court of justice, can never ignore. The Court has stated that its judgment must have some practical consequence in the sense that it can affect existing legal rights or obligations of the parties, thus removing uncertainty from their legal relations. It is not the function of the Court to provide a basis for political action if no question of actual legal rights is involved. Accordingly, the Court cannot adjudicate upon the merits of the claim when it considers that any adjudication would be devoid of purpose. The applicant requests the Court to adjudge and declare that there is no credible evidence that Ukraine is responsible for committing genocide in violation of the Genocide Convention in the Donetsk and Luhansk Oblast of Ukraine. The Court notes that its jurisprudence and that of its predecessor make clear that the Court may, in an appropriate case, issue a declaratory judgment. The purpose of a declaratory judgment is to ensure recognition of a situation at law, once and for all, and with binding force as between the parties, so that the legal position thus established cannot again be called into question insofar as the legal effects ensuing therefrom are concerned. The Court observes that the first aspect of the dispute between the parties involves a disagreement on a point of fact, as well as the interpretation, application, or fulfillment of their rights and obligations under the Genocide Convention. A declaratory judgment on whether there exists credible evidence that Ukraine is responsible for committing genocide in violation of its obligations under the Convention would have the effect of clarifying whether the applicant acted in accordance with its obligations under Article 1 of the Convention. In light of the foregoing, the Court finds that the Russian Federation's fourth preliminary objection to the admissibility of Ukraine's submission B in paragraph 178 of the memorial, based on the lack of practical effect of a potential judgment on the merits, must be rejected. In its fifth preliminary objection, to which the Court next turns, the Russian Federation contends that Ukraine's request for a declaration that the applicant did not breach its obligations is inadmissible. The Russian Federation argues that Article 9 of the Genocide Convention was not intended to cover such requests. The Court recalls that the text of Article 9 and observes that this article clearly allows a state that invokes the responsibility of another state to submit the dispute to the Court. The question before the Court is whether Article 9 precludes the possibility for a state to seek a declaration that it is not responsible for committing genocide in violation of its obligations under the Convention. The Court has considered the phrase, including those disputes relating to the responsibility of a state for genocide, to be an unusual feature of Article 9, pointing out that, according to the English text of the Convention, the responsibility contemplated is the responsibility for genocide, not merely responsibility for failing to prevent or punish genocide. The Court has also noted the exceptional inclusion of the term fulfillment in Article 9. Moreover, Article 9 specifies that disputes relating to the interpretation, application, or fulfillment of the Convention include disputes relating to the responsibility of a state for genocide, and provides that any of the state's parties to the dispute may submit a dispute to the Court. In light of these elements, the Court considers that Article 9 does not preclude the possibility for a state to seek a declaration that it is not responsible for committing genocide in violation of the Convention. The respondent further argues that Ukraine's submission B is incompatible with the judicial function of the court. The Russian Federation contends that by ruling on Ukraine's submission B, the court would be acting as an interim fact-finding body while criminal investigations are ongoing. In the court's view, to address Ukraine's submission B, it would have to make findings of fact in light of the evidence presented by the parties, and then apply the provisions of the Genocide Convention to the facts it has established. The court considers that it is an integral part of the judicial function to establish the facts in light of the evidence presented and apply the provisions of the Genocide Convention to the established facts. Accordingly, the court finds that the reasons advanced by the respondent cannot support the argument that Ukraine's submission B is incompatible with the judicial function of the court. Finally, the respondent argues that Ukraine's submission B contradicts the principles of judicial propriety and the equality of parties. To support this argument, the Russian Federation, referring to the principle of res judicata, argues that Ukraine's claim, if upheld by the court, may exonerate the applicant from responsibility by preempting the rights of the respondent and other states to invoke Ukraine's responsibility under the Genocide Convention in the future. The court states that it need not consider questions that may arise in the hypothetical situation where, subsequent to a judgment on the merits in the present case, the Russian Federation decides to institute proceedings against Ukraine, invoking the latter's responsibility for committing genocide in violation of its obligations under the Genocide Convention. The contents of a judgment on the merits are unknown, as is the substance of the claims the Russian Federation might make should it decide to seize the court. It is not for the court to speculate about these matters. It suffices for the court to observe that whenever a dispute is settled by the court by way of a judgment, there is a possibility that a future claim is covered by the res judicata effect of that judgment. This possibility, however, does not per se provide a basis for finding that Ukraine's submission B contradicts the principles of judicial propriety and the equality of the parties. In assessing the admissibility of Ukraine's request contained in submission B of its memorial, the court takes account of the circumstances in which the request was made. The court notes that in the present case, Ukraine made a request for a declaration that it did not breach its obligations under the Genocide Convention in the context of an armed conflict between the parties. The respondent took the allegedly unlawful measures in and against Ukraine with a stated purpose of preventing and punishing genocide allegedly committed in the Donbas region. In such a special context, the court recognizes the legal interest that Ukraine has under the Genocide Convention to resolve that dispute regarding its submission B. The court stated on 16 March 2022 that, I quote, "Since 24 February 2022, there has been intense fighting in Ukrainian territory, which has claimed many lives, has caused extensive displacement, and has resulted in widespread damage. The court is acutely aware of the extent of the human tragedy that is taking place in Ukraine." End of quote. The armed conflict between the applicant and the respondent continues to this day. A judgment of the court regarding submission B will clarify the rights and obligations of the parties under the Genocide Convention, in particular, whether Ukraine acted in accordance with its obligations under Article 1 of the Convention. The court is mindful of its responsibilities in the maintenance of international peace and security, as well as in the peaceful settlement of disputes under the Charter of the United Nations and the Statute of the Court. In the particular circumstances of the present case, the court considers that Ukraine's request for a declaration that it did not breach its obligations under the Convention is not inadmissible. In light of the foregoing, the court finds that the fifth preliminary objection of the Russian Federation must be rejected. The court next considers the sixth preliminary objection, whereby the Russian Federation contends that Ukraine's application is inadmissible because it constitutes an abuse of process. The Court recalls that it is only in exceptional circumstances that the Court should reject a claim based on a valid title of jurisdiction on the ground of abusive process. The Court has specified that there has to be clear evidence that the applicant's conduct amounts to an abusive process. An abusive process goes to the procedure before a court or tribunal and concerns the question whether a state has misused that procedure to such an extent that its case should be rejected at the preliminary phase of the proceedings. As to the respondent's argument that Ukraine introduced new claims in the memorial, the Court notes that it is the same as the one in the third preliminary objection, which it has already rejected in respect of the first aspect of the dispute. The Court next recalls that it cannot concern itself with the political motivation which may lead a state at a particular time or in a particular circumstance to choose judicial settlement. The Court is therefore not persuaded by respondents' argument that the timing of Ukraine's application is abusive. The Court then observes that in its order of 5 June 2023, it did not address the respondents' further argument that the manner in which Ukraine allegedly rallied states to arrange what the Russian Federation calls a mass intervention amounted to an abusive process. The Court's analysis in that order was limited to whether the declarations of intervention were inadmissible on the ground of an abusive process. The Court notes that in support of this argument, the respondent relies exclusively on the conduct and statements of the intervening states. It has not adduced any evidence regarding Ukraine's alleged abusive process. The Court does not consider that Ukraine, having established a valid title of jurisdiction, should be barred at this preliminary stage without clear evidence that its conduct with respect to interventions amounts to an abusive process. For this reason, the Court does not consider the third argument of the respondent convincing. The respondent has not demonstrated that there are exceptional circumstances that would warrant rejecting Ukraine's claim on the ground of abusive process. Accordingly, the Court finds that the Russian Federation's sixth preliminary objection to the admissibility of Ukraine's submission B in paragraph 178 of the memorial, based on abusive process, must be rejected. Having addressed the preliminary objections of the Russian Federation in relation to the first aspect of the dispute, the Court turns to the second aspect of the dispute. The Court notes that in subparagraphs C and D of paragraph 178 of its memorial, Ukraine requests the Court to, I quote, C, adjudge and declare that the Russian Federation's use of force in and against Ukraine, beginning on 24 February 2022, violates Articles 1 and 4 of the Genocide Convention, and D, adjudge and declare that the Russian Federation's recognition of the independence of the so-called Donetsk People's Republic and Luhansk People's Republic on 21 February 2022 violates Articles 1 and 4 of the Genocide Convention. End of quote. These submissions differ in their formulation from those in the application, in which Ukraine asks the Court to find, I quote, that the Russian Federation cannot lawfully take any action under the Genocide Convention in or against Ukraine aimed at preventing or punishing an alleged genocide on the basis of its false claims of genocide in the Luhansk and Donetsk oblasts of Ukraine. End of quote. To declare that the Russian Federation's recognition of the two, quote, so-called, close quote, republics was based on a false claim of genocide and therefore had no basis in the Genocide Convention, and to make a similar declaration regarding the special military operation conducted by the Russian Federation from 24 February 2022. The Court considers that it must first examine the question of the admissibility of the submissions in the memorial raised by the third preliminary objection of the Russian Federation. In light of the answer to that question, it will then consider whether the submissions related to the second aspect of the dispute fall within its jurisdiction, ratio materiae. In its third preliminary objection, the Russian Federation contends that the submissions in paragraph 178, subparagraphs C and D, of Ukraine's memorial are inadmissible because they differ from the claims in the application to the point that they change the nature of the dispute submitted to the court. The court observes that the wording of the claims presented by Ukraine in its application with regard to the second aspect of the dispute is certainly not identical to that of the claims set out in the memorial. It is true, as the Russian Federation points out, that none of the claims in the application refers specifically to Article 1 and 4 of the Convention, nor is there an explicit assertion that the Russian Federation violated its obligations under the Convention. By contrast, the submissions at the end of the memorial contain the explicit allegation that the actions of the Russian Federation violate the Convention and specify that, in Ukraine's view, the provisions violated are those of Articles 1 and 4 of the Convention. However, a difference in wording is not in itself decisive. What must be ascertained is whether the claim, as it is newly formulated, would transform the subject matter of the dispute originally brought before the court under the terms of the application. In this regard, the court notes that in paragraph 30, subparagraph B of the application, Ukraine submitted that the Russian Federation could not lawfully take any action on the basis of its false claims of genocide. In addition, in paragraph 26 of the application, Ukraine claimed that, I quote, the Russian Federation's declaration and implementation of measures in and against Ukraine in the form of a special military operation declared on 24 February 2022 on the basis of alleged genocide, as well as the recognition that preceded the military operation, is incompatible with the Convention. End of quote. This allegation is repeated in paragraph 29, according to which the actions of the Russian Federation, I quote, based on a false claim of genocide, are incompatible with the Genocide Convention and violate Ukraine's rights. End of quote. In asserting that the Russian Federation had acted unlawfully by carrying out actions incompatible with the Convention, which violated Ukraine's rights, the applicant was already challenging in the application the conformity of the Russian Federation's conduct with its obligations under the Convention and raising the question of the respondent's responsibility vis-à-vis the applicant, whose rights had purportedly been violated. Lastly, by presenting claims for reparation under submissions E and F of the application, Ukraine was necessarily calling into question the lawfulness of the actions undertaken by the Russian Federation. It thus follows from the foregoing that, from the very institution of the proceedings, Ukraine was not merely requesting that the court declare that it had not committed genocide, but was also seeking a finding that the actions of the Russian Federation were incompatible with its obligations under the Convention. It is true that the submissions at the end of the application were not without a certain ambiguity. It is also true that while Article 1 of the Convention was referred to several times in the application, there was no mention of Article 4. However, in the opinion of the court, the submissions in the memorial clarify Ukraine's claims and make them more specific without transforming the subject of the dispute such as it was submitted to the court in the application instituting proceedings. The court concludes that the submissions set out in paragraph 178, subparagraphs C and D of the memorial are admissible, and that, in this regard, the third preliminary objection raised by the respondent is unfounded and must be rejected. Consequently, the court examines the question of its jurisdiction, ration materiae, to entertain the second aspect of the dispute on the basis of the applicant's submissions as formulated in subparagraphs C and D of paragraph 178 of the memorial. In its second preliminary objection, the Russian Federation contends that it that the court lacks jurisdiction ratio materiae to entertain the claims in submissions C and D presented by Ukraine at the end of its memorial. According to the respondent, these claims fall outside the scope ratio materiae of the Genocide Convention and consequently do not fall within the scope of its compromissory clause. The court recalls that, according to its well-established jurisprudence, when the court is seized on the basis of a treaty's compromissory clause by a state invoking the international responsibility of another state party for the breach of obligations under the treaty, in order for the court to have jurisdiction, it is not sufficient for the applicant to claim an alleged violation of the treaty and for the respondent to contest it. It must be ascertained whether the actions or omissions of the respondent complained of by the applicant fall within the scope of the treaty allegedly violated. In other words, whether the facts at issue, if established, are capable of constituting violations of obligations under the treaty. This may require, to a certain extent, that the court interpret the provisions which have allegedly been violated and which define the scope of the treaty. In the present case, the acts complained of by Ukraine are, in essence, that the Russian Federation falsely accused the applicant of committing genocide and invoked the convention in bad faith in order to justify in an abusive manner its actions, particularly its military actions, which go against the limits of international law. According to Ukraine, these acts constitute violations of obligations under the convention. More specifically, the obligations allegedly violated are those under Articles 1 and 4 of the convention. Article 1 of the convention reads as follows, I quote, "The contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and punish." End of quote. Article 4, for its part, provides that, I quote, "Persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, whether they are constitutionally responsible rulers, public officials, or private individuals." End of quote. The court is of the view that, even assuming that the acts of the Russian Federation complained of by Ukraine are fully established, which it is not for the court to decide at this stage, they would not constitute a violation of obligations under Articles 1 and 4. Ukraine does not claim that the Russian Federation refrained from taking any measures to prevent a genocide or to punish persons who had committed such a genocide. On the contrary, the applicant claims that the genocide invoked by the Russian Federation did not occur, and the allegation was made in bad faith. The purpose of the first aspect of Ukraine's legal action is to request a finding by the court that there is no credible evidence that it had committed any such genocide. In these circumstances, it is difficult to see how the conduct of the Russian Federation complained of by Ukraine could constitute a violation by the respondent of its obligations to prevent genocide and punish the perpetrators. It is true that Ukraine seeks to demonstrate that the acts of which it accused the Russian Federation constitute violations of obligations under Article 1 and 2 of the Convention by relying on two grounds. The first is that the Russian Federation has invoked the Convention in bad faith and implemented its obligations abusively. The second is that the measures it adopted in invoking the Convention go beyond the limits permitted by international law. The Court observes that it is indisputable that every treaty in force is binding upon the parties to it and must be performed by them in good faith, referring to Article 26 of the Vienna Convention on the Law of Treaties, reflecting customary international law. More generally, the Court has recalled on a number of occasions that the principle of good faith is a well-established principle of international law and one of the basic principles governing the creation and performance of legal obligations. However, the Court has also stated that the principle of good faith is not in and of itself a source of obligation where none would otherwise exist. What matters for the purpose of establishing the Court's jurisdiction ratio materiae when it is seized of an application alleging a respondent's violation of an obligation under a treaty is whether the respondent state could have violated a specific obligation incumbent upon it, and whether the alleged violation falls within the scope of the court's jurisdiction. In the present case, even if the Russian Federation had, in bad faith, alleged that Ukraine committed genocide and taken certain measures against it under such a pretext, which the respondent contends, this would not in itself constitute a violation of obligations under Articles 1 and 4 of the Convention. The Court considers that it is no more convincing to argue that the respondent's conduct amounts to an abuse of right, or, as Ukraine sometimes puts it, an abuse of the Convention. It is certainly not consistent with the principle of good faith to invoke a treaty abusively by claiming that there is a specific situation falling within its scope when this is clearly not the case, or by deliberately interpreting the treaty incorrectly for the sole purpose of justifying a given action. However, when such an abusive invocation will result in the dismissal of the arguments based thereon, it does not follow that, by itself, it constitutes a breach of the treaty. In the present case, even if it were shown that the Russian Federation had invoked the Convention abusively, which is not established at this stage, it would not follow that the respondent had violated its obligations under the Convention, in particular that it had disregarded the obligations of prevention and punishment under Articles 1 and 4. As regards the applicant's argument that the actions undertaken by the Russian Federation on the basis of its false allegation of genocide go beyond the limits of international law, this raises a question that, in the opinion of the Court, does not fall within the scope ratio materiae of the Convention. Ukraine and some of the intervening states rely in this respect on the dictum in paragraph 430 of the judgment on the merits in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina v. Serbia and Montenegro. The Court stated in that judgment that the obligation to prevent genocide requires states parties to employ all means reasonably available to them so as to prevent genocide as far as possible, while adding that it is clear that every state may only act within the limits permitted by international law. However, it does not follow from the foregoing that if a state seeks to fulfill its obligation of prevention under the Convention through an act that is in breach of international law, such action by itself constitutes a violation of the Convention. The Court did not intend, by its 2007 ruling, to interpret the Convention as incorporating rules of international law that are extrinsic to it, in particular those governing use of force. It sought to clarify that a state is not required under the Convention to act in disregard of other rules of international law, nor can a state avail itself of the obligation of prevention under the Convention to act beyond the limits permitted elsewhere by international law. Those limits are not defined by the Convention itself, but by other rules of international law. Thus, in the present case, assuming for the sake of argument that by recognizing the DPR and LPR and by launching the so-called special military operation, the Russian Federation sought to implement its obligations under the Convention, and that the acts in question are contrary to international law, it is not the Convention that the Russian Federation would have violated, but the relevant rules of international law applicable to the recognition of states and the use of force. These matters are not governed by the Genocide Convention, and the Court does not have jurisdiction to entertain them in the present case. In conclusion, the acts complained of by Ukraine in submissions C and D of the memorial, from whichever point of view they are considered, are not capable of constituting violations of the provisions of the Convention relied on by Ukraine. These acts do not fall within the provisions of the Genocide Convention, and consequently, submissions C and D, which constitute the second aspect of the dispute, brought before the court by Ukraine fall outside the scope of the compromissory clause of Article 9. It follows that the second preliminary objection raised by the Russian Federation must be upheld. In view of the foregoing, it is not necessary for the court to examine the other objections raised by the Russian Federation inasmuch as they relate to the second aspect of the dispute. In summary, the court considers that the Russian Federation's second preliminary objection, according to which submissions C and D in paragraph 178 of Ukraine's memorial do not fall within the court's jurisdiction ratio materi, must be upheld. However, the court considers that it must reject the first preliminary objection based on the lack of jurisdiction of the court to entertain the totality of Ukraine's submissions because of the alleged non-existence of the dispute. The third preliminary objection based on the inadmissibility of the submissions presented in the memorial on the grounds that those submissions are allegedly new and transform the subject of the dispute. The fourth preliminary objection based on the inadmissibility of Ukraine's submissions because of the alleged lack of practical effect of a judgment on the merits. The fifth preliminary objection based on the inadmissibility of a request for a declaration that the applicant did not breach its obligations under the Convention. And the sixth preliminary objection based on the inadmissibility of the application on the ground that it allegedly constitutes an abusive process. It follows from the foregoing that submissions C and D in paragraph 178 of Ukraine's memorial do not fall within the jurisdiction of the court and that the court may not deal with them on the merits, while submission B in paragraph 178 of Ukraine's memorial does fall within the jurisdiction of the court and the claim contained therein is admissible. At the next stage of the proceedings, the court will therefore examine this claim on the merits. The court recalls, as it has on several occasions in the past, that there is a fundamental distinction between the question of the acceptance by states of the court's jurisdiction and the conformity of their acts with international law. States are always required to fulfill their obligations under the Charter of the United Nations and other rules of international law. Whether or not they have consented to the jurisdiction of the court, states remain responsible for acts attributable to them that are contrary to international law. I shall now read out the operative part of the judgment. For these reasons, the court, by 15 votes to 1, rejects the first preliminary objection raised by the Russian Federation. In favor, President Donahue, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Dode. Against, Vice President Gevorgyan. 2. By 12 votes to 4, upholds the second preliminary objection raised by the Russian Federation, which relates to submissions C and D in paragraph 178 of the Memorial of Ukraine. In favor, Vice President Gevorgyan, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Bandari, Salam, Iwasawa, Nolte, Brandt, Judge Ad hoc Dode. Against, President Donahue, Judges Sebutinde, Robinson, Charlesworth. 3. By 15 votes to 1, rejects the third preliminary objection raised by the Russian Federation relating to submission B in paragraph 178 of the Memorial of Ukraine. In favor, President Donahue, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad hoc Dode. Against, Vice President Gevorgyan. 4. By 14 votes to 2, rejects the third preliminary objection raised by the Russian Federation relating to submissions C and D in paragraph 178 of the Memorial of Ukraine. In favor, Judges Tomka, Abraham, Benuna, Yusuf, Shway, Sebutinde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad Hoc Daudet. Against, President Donahue, Vice President Gevorgyan. By 14 votes to 2, rejects the fourth preliminary objection raised by the Russian Federation. In favor, President Donahue, Judges Tomka, Abraham, Yusuf, Shui, Sebatunde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad Hoc Daudet. Against, Vice President Gevorgyan, Judge Benuna. 6, by 13 votes to 3, rejects the fifth preliminary objection raised by the Russian Federation. In favor, President Donahue, Judges Tomka, Yusuf, Shui, Sebatunde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad Hoc Daudet. Against, Vice President Gevorgyan, Judges Abraham, Benuna. 7, by 15 votes to 1, rejects the sixth preliminary objection raised by the Russian Federation. In favor, President Donahue, Judges Tomka, Abraham, Benuna, Yusuf, Shui, Sebatunde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad Hoc Daudet. Against, Vice President Gevorgyan. 8, by 15 votes to 1, finds that it has jurisdiction on the basis of Article 9 of the Convention on the Prevention and Punishment of the Crime of Genocide to entertain Submission B in paragraph 178 of the Memorial of Ukraine. In favor, President Donahue, Judges Tomka, Abraham, Benuna, Yusuf, Shui, Sebatunde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad Hoc Daudet. Against, Vice President Gevorgyan. 9, by 13 votes to 3, finds that Submission B in paragraph 178 of the Memorial of Ukraine is admissible. In favor, President Donahue, Judges Tomka, Yusuf, Shui, Sebatunde, Bandari, Robinson, Salam, Iwasawa, Nolte, Charlesworth, Brandt, Judge Ad Hoc Daudet. Against, Vice President Gevorgyan, Judges Abraham, Benuna. I shall now call on the registrar to read the operative part of the judgment in French.
Par ces motifs, la Cour, 1. Par 15 voix contre 1, rejette la première exception préliminaire soulevée par la Fédération de Russie pour Madame Donoyou, présidente, Messieurs Tomka, Abraham, Benuna, Youssouf, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brandt, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Gevorgyan, vice-président. 2. Par 12 voix contre 4, retient la deuxième exception préliminaire soulevée par la Fédération de Russie qui se rapporte aux conclusions figurant au point C et D du paragraphe 178 du mémoire de l'Ukraine. Pour M. Gevorgyan, vice-président, Messieurs Tomka, Abraham, Benuna, Youssouf, Madame Choué, Messieurs Bandari, Salam, Iwasawa, Nolte, Brandt, juge, Monsieur Daudet, juge ad hoc. Contre, Madame Donoyou, présidente, Madame Sebutinde, Monsieur Robinson, Madame Charlesworth, juge. 3. Par 15 voix contre 1, rejette la troisième exception préliminaire soulevée par la Fédération de Russie relativement au chef de conclusion figurant au point B du paragraphe 178 du mémoire de l'Ukraine. Pour Madame Donoyou, présidente, Messieurs Tomka, Abraham, Benuna, Youssouf, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Gevorgyan, vice-président. 4. Par 14 voix contre 2, rejette la troisième exception préliminaire soulevée par la Fédération de Russie relativement aux conclusions figurant au point C et D du paragraphe 178 du mémoire de l'Ukraine. Pour Messieurs Tomka, Abraham, Benuna, Youssouf, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Daudet, juge ad hoc. Contre, Madame Donoyou, présidente, Monsieur Gevorgyan, vice-président. 5. Par 14 voix contre 2, rejette la 4e exception préliminaire soulevée par la Fédération de Russie. Pour, Madame Donoyou, présidente, Messieurs Tomka, Abraham Youssouf, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Gevorgyan, vice-président, Monsieur Benouna, juge. 6. Par 13 voix contre 3, rejette la 5e exception préliminaire soulevée par la Fédération de Russie. Pour, Madame Donoyou, présidente, Messieurs Tomka, Youssouf, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Gevorgyan, vice-président, Messieurs Abraham, Benouna, juge. 7. Par 15 voix contre 1, rejette la 6e exception préliminaire soulevée par la Fédération de Russie. Pour, Madame Donoyou, présidente, Messieurs Tomka, Abraham, Benouna, Youssouf, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Gevorgyan, vice-président. 8. Par 15 voix contre 1, dit qu'elle a compétence sur la base de l'article 9 de la Convention pour la prévention et la répression du crime de génocide pour connaître du chef de conclusion figurant au point B du paragraphe 178 du mémoire de l'Ukraine. Pour Madame Donoyou, présidente, Messieurs Tomka, Abraham, Benouna, Youssouf, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Gevorgyan, vice-président. 9. Par 13 voix contre 3, dit que le chef de conclusion figurant au point B du paragraphe 178 du mémoire de l'Ukraine est recevable. Pour, Madame Donoyou, présidente, Messieurs Tomka, Youssouf, Mesdames Choué, Sebutinde, Messieurs Bandari, Robinson, Salam, Iwasawa, Nolte, Madame Charlesworth, Monsieur Brand, juge, Monsieur Daudet, juge ad hoc. Contre, Monsieur Gevorgyan, vice-président, Messieurs Abraham, Benouna, juge.
President Donahue appends a separate opinion to the judgment of the court. Vice President Gevorgyan appends a dissenting opinion to the judgment of the court. Judge Tomka appends a declaration to the judgment of the court. Judge Abraham appends a partially dissenting opinion to the judgment of the court. Judge Benouna appends a declaration to the judgment of the court. Judges Sebutinde and Robinson append a joint dissenting opinion to the judgment of the court. Judges Iwasawa and Charlesworth append separate opinions to the judgment of the court. Judge Brandt appends a declaration to the judgment of the court. Judge ad hoc Daudet appends a separate opinion to the judgment of the court. The text of the judgment is available from today in typescript. It will also be available shortly on the court's website. The printed text will be available in the near future. As the court has no further business before it today, I declare the sitting closed.
Das Ensemble Consortium Classicum interpretierte von Josef Gabriel Reinberger das Andante aus dem Sextett in F-Dur.
Das war der zweite Satz, Andante con moto, aus der Sinfonie Nummer 5 in B-Dur von Franz Schubert. Es spielte das Kammerorchester Basel, Dirigent Heinz Holliger.
Radio Swiss Classic. Das Klassikradio der SRG SSR